Hello and welcome to Mackenzie Friend. Today we're going to do a very sort of difficult subject about contravention and enforcement of pairing orders. First, the usual disclaimer: whilst I hold a law degree majoring in family law, I choose not to practice nor seek admission. Therefore, any information cannot be relied upon. Specific questions should be directed towards an accredited family law specialist. Okay, let's look at the issue. The other parent has failed to abide by orders. What are the options? Okay, first of all, we have to look at what exactly are you trying to achieve. Is it just merely compliance with the pairing orders? Is it changes to the pairing orders? Or is it punishing the other parent? So there's a few considerations we need to look at. We need to look at the type of order. Are they interim, final, and how old are the orders? Also, the extent and nature of the order being breached. Is it just one order? Is it many orders? Is it on multiple occasions? Sort of looking at the iniquity of the actual conduct by the breaching party. Also, we need to look at the excuse for the non-compliance. Was the excuse reasonable? Was someone failed to bring the child to handover because the car broke down? A legitimate excuse? Or was it they are punishing you or they're just misbehaving? Also, we need to know what orders would fix the situation. Is it a matter of just changing the orders that makes it more difficult for the other party to not abide by the orders? So let's look a little bit about the types of orders that are not being abided by. Is it an issue of parental responsibility? Is it that you're not being involved in long-term decisions on health, education, religion, cultural, child's name, or relocation? Is this to do with location recovery because the other party has unilaterally relocated? Or is this just a disagreement on day-to-day issues that may not fall under the orders? Is it an issue pertaining to contact, not making the child available, or just being persistently late, or just being difficult, or a person being present at the handover that shouldn't be there? Or is it something else? Is it about the rights for a child to travel, to visit people? Traveling overseas is often a point of contention. Is it a matter that the other parent is continuing to denigrate you? Is this an issue of Section 121 on the prohibition of publication? So, other considerations are the wishes of the child. Like when the child becomes a certain age, if they can express their view, and the court will attach weight to that. If the child doesn't want to see the other parent, is that a generally held position by the child? Is the child old enough and has the capacity to make that decision? Is this represented by a parent and perhaps subject to parental influence? Also, what is it? It might be about interpretation of orders. Often in matters, parents have differing opinions on what the order actually says and what it's supposed to mean. So, there might be uncertainty or ambiguity of the orders. Also, there's an issue of maybe spirit and substantial compliance, which is an issue that's currently happening with the COVID-19 public health orders. So there's a choice on what sort of path you can take. The best course of action depends on consideration of all the facts and circumstances. Also, it looks at the existing orders, like does the parent who is raising contravention have parental responsibility? Because parental responsibility is seen as a significant factor in these matters. Like if you're a parent that has low amount of contact and no parental responsibility, then you're not in a particularly strong position in making these sort of applications. Maybe you've only got supervised contact. The contact centre is now closed. Does that mean that the other parent has a reasonable excuse for not abiding by the orders? And also, it's important for the court and to look at the reasons given by the other party acting contrary to the orders. Also, other factors the court might consider would be the family violence and assistance and protection orders. If there may be a history of litigation and other applications, the court may not be favourable if a parent has either been subject to multiple contravention applications or the other parent is seen by the court to be litigious or just being difficult. Also, they might look at the adherence to orders, like how long the order's been placed, how generally the parents have abided by the orders. Also, the residual acrimony. If there's still acrimony between parties after a significant amount of time after the order's been handed down, the court may have serious concerns that parents will not be able to cooperate or co-parent into the future. And also any delay in instigating proceedings. Like, it's difficult to raise a contravention application, which happened, a significant amount of time before. Also, if a parent is seeking to, say, withhold the child, then they should be going to the court and seeking orders to put that into the orders and into effect, rather than just deciding unilaterally to not abide by the orders. And also, perhaps to a lesser degree, the mediation of outcome, like how parties, facilitators, or behaved during mediation. Did they turn up? Were they being unreasonable? Because that's sometimes detailed in the Section 60I certificate, and exactly what sort of basis the certificate was made upon. Right, so you basically got two fundamental options. One is the punitive path, which is through contravention applications. And the other is perhaps just seeking changes to the orders, like through an application in a case, or even possible to appeal. But remember, appeal has time limits, and outside the statutory time limits, leave must be sought and granted. I think the time limits are about 28 days. So realistically, it'd be difficult to probably bring an appeal after, say, 6 months. Also, when we look at the application in a case, it might be arguable that a parent's failure to abide by orders may be considered a change in circumstance, such to enliven the court's jurisdiction to make amendments to orders. But certainly the application in a case is more focused towards change to orders rather than being punitive. All right, let's look at the punitive path, which is essentially contravention orders, which I often see in a lot of Facebook posts, and it may not be the best option, and there are certainly some difficulties associated with it. So let's have a look at that. All right, firstly, under Section 7, which is Children Division 13A, deals with the consequence of failure to comply with orders and obligations that affect children. So, a quick comment: contravention proceedings are pseudo-criminal proceedings with potentially serious sanctions. Unless the conduct is serious, it is not unusual that the court is reluctant to uphold that a party contravened orders without reasonable excuse. Alternatively, if the contravention is upheld, then consequences to the offending party may be minor. Now, we need to look at what's meant by contravening an order. We find that under Section 70 NAC of the Family Law Act, and also what is meant by a reasonable excuse. Now, I approach express there are dangers to running contravention applications. A contravention application is not primarily intended to change orders, but rather to punish non-compliance. The court has the power to change orders or make a cost order against the unsuccessful party. So you might run a contravention, the person might have a reasonable excuse, and they'll make a cost order against you. And also, it may not be helpful if you in the future have to run another application of contravention. Now, under Section 13A subdivision B, confers to the court the power to vary a primary order, whether or not a contravention is established. So the court does have power to make changes to orders, irrespective if the contravention is upheld. 13A subsection C confers to the court the power to make a cost order against the applicant if the alleged contravention is not established. There's a risk in costs. Now, it's very important, as we know under Section 60CA of the Family Law Act, the court will make orders in the best interest of the child which may be detrimental to the applicant. So there has been times when an applicant made a contravention application, and just due to acrimony or the court was annoyed enough that the orders sought by the applicant were actually diminished. The contact time was diminished because the parents were just so unable to effectively co-parent for the best interest of the child. So there is a danger that it could act against you. Right, let's go back and look at the Family Law Act under Section 13A subdivision D, which sets out the court's powers when a contravention is established, but the respondent provides a reasonable excuse. So the court can make an order for compensatory time, cost order against the respondent, or vary the primary order. Often you might, there's circumstances where the other parent has to make the child available at, say, McDonald's or the other parent's residence, but you might want to seek orders where the other parent picks the child up from school, which is obviously more difficult for the other parent to obstruct. Now, Division 13A subsection E sets out the court's powers when a less serious contravention is established and the respondent does not have a reasonable excuse. So this is a grade down from the most serious contraventions. So the court may make an order for compensatory time, cost order against the respondent against the respondent. That's wrong. Cost order against respondent. Okay. Pay compensation or expenses, but if you're not legally represented, it's difficult to claim legal costs. The parent to attend a post-separation parenting program, enter into a bond, or vary the primary order. Okay, looking at Division 13A, Subdivision F sets out the court's power when a serious contravention is established and the respondent does not have a reasonable excuse. Now, the court may make an order against the respondent, could be a community service order, could impose a prison sentence, could enter into a bond, impose a fine up to 60 units, could impose a cost order, especially if the party is represented, pay compensation or expenses, compensatory time, or vary the primary order. But pretty much the court can do whatever they like. Now, so the considerations before filing. You should attempt to resolve the matter by writing to the other party. You should attempt mediation, and 60I is usually a pre-filing requirement unless it's an exemption under 60I 9. So the material to be filed is the contravention application. An affidavit, like most affidavits, must be in accordance with Rule 25 of the Federal Circuit Court rules, or 21.02 of the Family Law Rules. You need to have the valid 60I certificate or exemption and a filing fee, but for the case of contravention, there isn't a filing fee. Now, these documents must be served personally on the respondent, and that's usually done by a process server, such as the sheriff of the court. The person who is initiating the application cannot serve the other party personally. You might be able to serve their legal representation if their legal representation is accepting service. And you should also have an acknowledgement of service and affidavit of service, which can be filed as well. Usually, because the contravention doesn't necessarily require a response to be filed, that's why it's important to actually have an acknowledgement of service. Right. Now, this is important about the contravention application itself. Such an application, because of its pseudo-criminal nature, requires precision and technicality. The application must be correctly pleaded. The order contravened must be specifically identified. The time, date, and location must be accurately detailed. There must be a brief description of the event. The respondent must clearly need to know the case to answer. The courts are generally not favourable to contravention applications and will impose a high degree of technicality. So, the elements of a contravention. The applicant must prove with admissible evidence and support the facts and terms of the order alleged to be contravened. The respondent knew of the terms of the order at the time of the alleged contravention. The orders were enforced at the time of the contravention because they could have been suspended by a protection order. Also, contrary to order, the respondent did or failed to do what was required by that order. So you'll need to see the sections of the Family Law Act under 65M, 65N, 65NA, and 65P. And the applicant did all things required under the orders to enable the respondent to comply. So you can't just not turn up to the handover and claim that the other party contravened. You must do your obligation under the orders to effect the order. Right, it's probably best if we look at an example allegation. This is how you might detail the contravention in the contravention application. You might say, at 10 a.m. on Saturday, 12th May 2019, the mother or the father did not make the child available at Wollongong McDonald's as per Order 5 of the final orders dated 1st February 2018, and the father or mother waited until 8:45 until 11 a.m. So what in this example shows that exact time, date, place, order, and which orders were in effect that order applied to. Then later on, you've got to detail the court, what you did. You said you waited from 8:45 until 11 a.m. That says that you were there in order to effect the order. Now, then you might also add, the mother-father sent an SMS to the mother's father's mobile at 10:45 asking why the child was not at handover, and then you put that as a screenshot into an annexure. And the respondent mother at 11 a.m. stating that because the father or mother was in arrears for child support, that the mother will not be making the child available until the outstanding child debt is paid in extra aid. Now, this is what you've done, is you've detailed the excuse that you've received. Now, the other party may not reply at all, but at least it will be more difficult for that party to go forward and make up another excuse later on. Now, I picked the child support one because that is not, would probably not by the court be considered a reasonable excuse for contravening the order. Right, so if you're on the receiving end, if you're the respondent for a contravention application, let's talk about filing a defence. There is no form to file a response to a contravention application. The defence can be filed on the day of the hearing. However, the respondent may file an affidavit in response, placing the onus back on the applicant to prove their case. So you don't really want to go to court. You don't want to have to pay for representation because you want to stay out of court. So you might respond back detailing your reasonable excuse or interpretation of the orders or something that will put enough reasonable excuse on that the other party may not bring the matter before the court. Now, also the respondent can seek a variation of the order. So if there was an issue of ambiguity or there is some risk to health and safety of parties, then you might be able to seek a variation of the order. Now, although a cost order may be sought if the application is unsuccessful, the court may not make that order or split costs if only one party is represented. So what has happened in some situations where a contravention application has been unsuccessful, however, one party was represented, but the court decided to take the costs from the represented party and split between both parties. Basically, they were just trying to punish both parties and stop them coming back again. Now, the proof of a contravention is on the balance of probabilities. That's important, but I feel it's slightly higher than that. You would have to be fairly certain of the events or circumstances to make that. Now, the respondent must prove facts sufficient to make out a reasonable excuse. So you have to make out an excuse. If you don't, then it's just deemed that you didn't have one. So the excuse must be reasonable. Like as I said in the previous example, the non-payment of child support may not be sufficient, but maybe a car breaking down, the child being sick, or something might be considered as a reasonable excuse. Now, if the contravention is ongoing, any reasons for the delay in instigating proceedings to vary and discharge the orders must be provided. So the withholding party, in the case of contact, is expected that if they want to continue to not abide by the orders, then there's an obligation upon them to go back to court, all by consent, and change those orders. You can't just decide not to abide by the orders. That is insufficient. So let's have a look at the defence of reasonable excuse under Section 70 NAE. So Section 70 NAE means meaning of reasonable excuse for contravening an order. To a person, the respondent, is taken to have a reasonable excuse for contravening an order under this Act affecting children if the respondent can contravene the order because or substantially because he or she did not at the time of the contravention understand the obligations imposed by the order on the person who was bound by it. That might be they just didn't understand the order, there was ambiguity, you might have had an agreement outside that order with the other party, or simply the court is satisfied the respondent ought to be excused for the contravention. So the court may find the contravention and just decide to excuse the party just because of facts and circumstances. This may be because of protection orders, family violence, history of litigation, all those factors. So the court can pretty much do what it likes. Now let's have a look at some typical reasonable excuses. This is where it was necessary to protect the health or safety of a person, which could be if there was an issue of family violence or perhaps with the current COVID-19 issue, and it was not longer than necessary to protect the health and safety of the person. So you can't use this excuse indefinitely. So if you want to have some more information on that, look at the marriage of O'Brien. Now, the orders were not understood by the respondent, as mentioned earlier. They were ambiguous, or they conflicted with other orders. Often, sometimes, orders particularly with progressive changes to contact, or they have the orders come in effect after certain things have been satisfied, like attending parenting courses or having number of clean substance or alcohol tests, and then they come into effect, and sometimes there's some difficulty with the understanding by parties that those milestones have been reached. It may be that parties reach an alternative agreement. It might be that you came to a private agreement on a certain day, and then you turned around subsequently later and decided that, oh, I don't want to abide by that, and resort back to the other orders, and then try to run a contravention on it. I don't think the court would be impressed when the court has shown that you've come to an alternate agreement, now you're changing your mind. And also the conduct of the other party. You know, if the other party is maybe denigrating or being abusive or things like that, you know, when you come before the court for such a serious application, you have to come with clean hands. That's very important. Also, that it must be significant to the best interest of the child. Now, you might have a protection order that suspended the operation of an order. So, you know, you can't bring a contravention if a protection order, which was knowingly made in the presence of parenting orders, suspended, varied or discharged an order for contact. Now, we're going to get down to some more interesting things about the child's desire not to see the other parent. This is not that straightforward, and I don't think it's a reasonable excuse. It depends on many facts and circumstances, so I'm going to leave that one a little bit open. We're going to talk about that one in a moment. All right, let's go back. I mentioned previously about the marriage of O'Brien, and it's about health and safety, and this is the comment by His Honour Smithers J. Now, it seems to me that it makes it clear that a reasonable excuse in respect of concerns as to the welfare of a child is limited to the belief on reasonable grounds that depriving a person of access pursuant to an order was necessary to protect the health and safety of a person. It's not a question as to whether the view of the custodial parents or in the view of the custodial parents on reasonable grounds that carrying out the access order might not be in the best interest of the child. The question is whether it's necessary to protect the health or safety of a person, including the child. So what he's saying is that he's setting out a threshold and a barrier, and it must be on reasonable grounds, and it must be necessary to protect health and safety. So let's look at desirably of contact. This comes up often, where a parent may say to the other parent, oh, I'm not dropping the child, you know, to hand over today because the child doesn't want to go and see you. Now, this was dealt with in Galt and Gaunt, and also later in Wilson and Wilson. The general belief of the custodial parent that access would not be in the interests of the child did not constitute just cause for not complying with the order. The court made it clear that although the access order was open to variation under the Act in appropriate circumstances, while it stood the opinion of the custodian as desirability of access did not constitute just cause or excuse for interfering with the operation of the order. So what they're saying is that just because the child doesn't want to go doesn't necessarily mean it's not in their best interests, and parents should facilitate the orders. However, there are mechanisms in place in the Family Law Act to go back to court to amend those orders if the views of the child would be significant consideration for the changing of those orders. So let's go back. We went down the punitive punishment path, and as you can see, it's quite technical and difficult, and it's not necessarily lightly entertained by the court. The other option is you might want to just run a simple application of the case. The court may be more amenable to the court if a party fails to abide by the orders without reasonable excuse that the orders are not working and should be varied or discharged in the best interest of the child. So, as I said, you might want to just go forward and seek orders for handover at school. The non-compliance could be argued as a change of circumstance, allowing the orders to be changed under the principles of Rice and Aspone. Rice and Aspone basically is a significant change of circumstances. It's often an argument used to make amendments to orders. It's not an excuse to relitigate the issues that were already being determined at a contested hearing in front of the court. So this is more like it's a maintenance mechanism. So you would say, well, say the mother lost her driver's license and she said, oh, I can't drop the child over to Wollongong McDonald's. You just go say, oh, okay, look, if you can't come to an agreement, then you go back to court and say, oh, okay, now I'll just pick the child up from school. Simple as that. So as I said there, this application not intended to be used as a method of relitigation and again, agitate issues which have been determined at final hearing. The court will not be amenable to any application, such an application, a case this matter, or a rice and acid plan type application, if it looks like it's being used to just re-agitate facts and circumstances that have already been determined. The other one I mentioned briefly is an appeal. This is a very different kettle of fish. An application review leads to a rehearing of the whole matter, in other words, from de novo, from the start. This is a very serious undertaking. It requires finding an error of law, not fact. You would have to strongly argue there was some best interest of the child. Usually appeals are unsuccessful. They require appeal books to be generated, which is an expensive task, and often they'll make cost orders are not unusual against the unsuccessful party. So the application must be made within the Federal Circuit Court rules or the family law rules. If you're outside the statutory limits, again, leave must be sought and granted. Appeals are highly technical, expensive, and cost orders may be made against the unsuccessful party. Applications associated with judicial discretion must focus on an error of law which is distinct from an error of fact. The appeal court may make orders it considers appropriate, including an order affirming, reversing, or varying the order. So they may not send it back, but they may just make some changes to the orders. An appeal might be, oh, the final was made, but they've forgotten a provision with regards to overseas travel. It might be possible to appeal it and say that orders should be so the child can travel overseas with a parent under certain conditions. An appeal application does not stay the orders. In other words, while that appeal is awaiting to be heard and the appeal decision is handed down, the current orders remain in effect. Even consent orders can be appealed. All right, so let's look in conclusion. Firstly, I think expert legal advice should be sought before instigating proceedings. Costs and changes in orders could arise if a party is unsuccessful. Proposed changes in orders may not be in the best interest of the applicant. The principle of finality of proceedings deters re-agitation of proceedings. In absence of a new and compelling evidence, the court will be reluctant to entertain issues that have already been considered in a contested hearing, so don't re-agitate. And the best interest of the child will be the paramount consideration. I hope this helps.